Assalamualaikum warahmatullahi wabarakatuh. Today, our group gonna talk about discharge of contract.
Discharge of contract happens when parties to the contract are released from any obligations arises under the contract. In other words, parties to the contract are no longer obligated to do as agreed under the contract. Contract can be released in 4 ways, which are by performance, agreement, breach of contract, or by frustration. The first one is discharge by performance. Performance is the most common way to discharge a contract. A contract is said to be discharged when the parties to the contract has performed what they have agreed to do in the contract. In order to discharge a contract, the performance of an obligation must be done strictly in accordance with the terms of the contract, unless otherwise agreed. The parties to a contract must be prepared to perform their respective obligations at the time and place stipulated in the contract. Time of performance is where a contract is to be performed on a certain day. According to Section 49 of Contract Act 1950, the promisee must apply for the contract to be performed at a proper place and within proper business hours if the promisor has not undertaken to perform it without application by the promisee. However, according to Section 48 of Contract Act 1950, if a promisor had undertaken to perform the contract without application from the promisee, he may perform it at any time during the usual business hours on the day and the place where the contract ought to be performed. Section 50 Contract Act 1950 provides that where the place for the performance had not been determined by a contract, then it would be the duty of the promisor to ask the promisee where he would want the contract to be performed if the performance is to be effected without the promisee's application. In a executory contract, for example, according to Section 52 Contract Act 1950, a promise and its consideration is to be performed simultaneously at a future date. No promisor need to perform his promise unless the promisee is ready and willing to perform his reciprocal promise. According to Section 32 Contract Act 1950, contingent contracts are contracts to do or not to do something depending on some event collateral to the contract does or does not happen. Tender of performance will be used in order to be discharged of their contractual obligations. The parties must perform or offer to perform their respective obligations according to Section 38 Contract Act 1950. Where one party has made an offer to perform his obligations exactly under the contract and was rejected by the other, the former will be freed of his obligations. Section 39(2) Contract Act 1950 provides that to be effective, the tender of performance must fulfill the following conditions. First, it was unconditional. Second, it was made at the proper time and place. Third, it was made under the circumstances that the other party may have the reasonable opportunity to ascertain the promisor is able and willing there and then to perform the whole of his obligation. Fourth, if the offer is to deliver something, the promise must have reasonable opportunity to see the thing offered to be delivered is the thing the promisor is bound to deliver. Personal performance is whether or not the parties to a contract are required to personally perform their respective obligations, dependent on their intentions at the time the contract was made, according to Section 41 Contract Act 1950. Where personal performance is not implied, a promisor may apply a competent third party to perform his obligations, but he still remains personally liable. Section 42 Contract Act 1950 provides that the promisee, once he has accepted performance by a third party, cannot afterwards seek to enforce it on the promisor. The second one is discharge by agreement. Contract may be discharged by agreement when parties to the contract agree under free consent to discharge obligations from the former contract. A contract can be discharged if the parties agree or give consent that the contract will be discharged. The agreement can be made during the contract or after the contract has been made. Section 63 of the Contract Act 1950 provides that the parties can agree either substitute an existing contract with a new one or rescind the original contract or alter the original contract. A novation is the substitution of the existing contract with a new one. The consideration for this new contract is the mutual discharge of the original one. A waiver or a release is where one party to a contract waives his right by releasing the other party from having to perform his contractual obligations. The remission can be either wholly or partially as provided under Section 64 of the Contract Act 1950. The application of the dispensation or remission of performance provided under Section 64 can be seen with the following situations. First, the payment of a lesser sum to satisfy the whole debt. Second, payment of a lesser sum by a third party to satisfy a larger debt. Third, payment in satisfaction of an unascertained sum. Lastly, an arrangement for the settlement of debts between a debtor and his creditors. The third one is discharge by breach. Under Section 40, when a party to a contract has refused to perform or disable himself from performing his promise in its entirety, the promisee may put an end to the contract. A contract can be put to an end if a party to the contract did not do what they have promised in the contract. A breach may occur because of refusal or disability to perform. Refusal to perform is where one party informs the other by conduct or words that he does not want to go on with the contract. The former party is said to repudiate the contract. Disabled to perform is if one of the parties is disabled to perform, the contract is discharged. Then it does not amount to a breach of contract, but is discharged through frustration. Actual breach occurs when performance is die on or in the course of performance. It can either be a failure to tender any form of performance or performance is inadequate. The effect of an actual breach is that where the innocent party terminates the contract, he must restore or return any benefits received from other party under Section 65 of Contract Act 1950. Further, if the innocent party has provided services or supplied goods, he can recover reasonable sum for it. The party who is not in breach of contract has two options, whether to continue with the contract and claim damages or repudiate the contract.
Next, we have discharge by frustration. What is discharge by frustration? If a contract is frustrated, it is automatically discharged at the time of frustration. This means that the parties to the contract do not need to perform any future contractual obligation. A contract is terminated if the things that the parties agree to do is impossible to perform. It can be at the time the contract was made or when the contract has been made the obligation become impossible to perform. First, types of impossibility. In Section 57 Contract Act 1950, contract the performance of which is impossible at the time it was made an agreement to do in impossible act, such contract are void. Next, at Section 57 Contract Act 1950, a contract the performance of which had become impossible or unlawful after it was made due to some event the promisor could not prevent. The contract is said to have been frustrated, the doctrine of frustration, and become void. Effect of discharge by impossibility. When a contract becomes void for frustration, Section 66 Contract Act 1950 provide that any person who has received any advantage under it is bound to restore it or to compensate the person from whom the advantage was received. Next, we're gonna talk about remedies for breach of contract. So, definition of remedies for breach of contract is: remedy is a general term which means a right that can be claimed by a party to a contract that experienced loss because of the other party to the contract was in breach. Next, we have many types. We have types: damage, specific performance, and injuction or quantum meruit. First for all, we have damage. Damage given to a person in a contract who does not receive the right that he should from the contract. A person that claims damage must prove that the loss incurred because of the breach, the loss are commonly incurred, and both parties expected to the loss to incur if the contract is breached. For the example, Hadley versus Big Sender and Kyoto vs Associated Metals Smelter Ltd. Hadley versus Big Sender. Plaintiff contract which defendant to bring a machine from plaintiff factory to a machine maker as a model. Defendant was late. As a result, plaintiff factory cannot operate. Plaintiff claim damage for profit loss. Plaintiff claim was reject the loss incurred because the other machine is not functioning. Besides, both parties do not expect the loss to incur. In Kyoto versus Associated Metals Smelter Ltd, court decided that a failure to send a smelter that could burn up to 2600 degrees Fahrenheit is a breach of contract. Defendant can expect the loss that might incur from that breach. Damage have two types, is damage of specific and damage of unspecific. Damage of specific is damage by which the amount has already been agreed upon if there is a breach. Next, damage of unspecific have three, which is substantial, nominal, and exemplary. Substantial is a reward given is to put plaintiff in a place that he should if defendant perform the contractual obligation. Nominal is a small reward to plaintiff after he show that there is a breach of contract, even though there is no real losses incurred. Last, exemplary, a reward given is far higher than the loss incurred. Next, we have specific performance. It is an order by court to parties to a contract to perform as contract. Under Specific Relief Act 1915, a court gives this order in a situation if the contractual obligation is a trust. Actual damage cannot be ascertained or breach cannot be adequately relieved by compensation of money. Next, we have injunction. Injunction is discretionary given by court under Section 15. Specific relief action and injunction may be of mandatory or intellectuary. The remedy of an intellectuary injunction is used by a party to maintain status quo of a subject matter in impending suit. A mandatory injunction is a court order requiring something to be done. An injunction may also be in a form of restraining order, stopping something from being done. Next, we have quantum meruit. This is last. A claim that can be made by plaintiff who has performed obligation under a contract and then choose to resign the contract after defendant breach. Court will order a value that is advocated.